while granting the stay order, my lord, they completely misleaded this court, my lord. Here, my lord, the directorate of that is DCRE keeps the complaint in the cold storage for close to 3 years.
Yes.
Communicates to the jurisdictional police directing registration of crime. Learned counsel for the petitioner would submit that he has applied for anticipatory bail. Is not granted without hearing the complainant. In the light of the offense under Atrocities Act, he would further submit that the complainant has sought umpteen adjournments in the criminal appeal. There is no single adjournment the respondent number 2 has taken.
ಸುಳ್ಳು ಹೇಳಿ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ನಿಮ್ಮ allegation.
Yes, no, they have.
I will accept it that you have not taken any adjournment. I will correct this order. Don't worry.
No, my lord.
Absconding charge sheet ಹಾಕಿರ್ಲಿಲ್ಲ.
Has filed an absconding charge sheet against the petitioner. A C report. It's a regular charge sheet, my lord.
Regular charge sheet is filed.
It's a regular charge sheet being
C
filed.
report.
Absconding.
What do you mean absconding charge sheet?
No, my lord. But
What do you mean absconding charge sheet?
But
Now you told me it's a regular charge sheet. Is it a regular charge sheet?
My lord,
Is it a regular charge sheet? ಇಲ್ಲ ತಾನೆ? Don't get it. You're a counsel. Don't get into the shoes of the client.
No.
This is what was challenged before the Supreme Court.
Yes.
This order is not set aside. So this order has
My
been
lord,
confirmed. 1 minute. This order is confirmed.
High Court
Correct.
order is confirmed.
Correct. So now don't go back to this order. Any correction ಮಾಡಬೇಕು ಅಂದ್ರೆ I'll do it. If you harp upon nitty-gritty of this order which is confirmed by Supreme Court, I'll not even touch it.
No, my lord. The stay order, while granting the stay order, my lord, they completely misleaded this court, my lord.
All right.
I'll just go through the.
You want time?
No, my lord.
ಹೇಳಿ.
In page number 259,
Yes,
which is
your
filed
petition. Yes, sir. You have completed your submission.
Yes.
by in the objections filed by me.
I am there. Tell me.
Here, my lord, the directorate of that is DCRE keeps the complaint in the cold storage for close to 3 years.
Yes.
Communicates to the jurisdictional police directing registration of crime. Then comes the crime number registration. My lord, thereafter, I'll just go through the time, my lord. The narration of the crime, because what I am elaborating, my lord, here, they made all the statements. They have not, they kept on, it was a very prolonged arguments, definitely from their side, while granting the interim order. But the point is, my lord, here, learned counsel for the petitioner would submit that he has applied for anticipatory bail. He is not granted without hearing the complainant. In the light of the offense under Atrocities Act, he would further submit that the complainant has sought umpteen adjournments in the criminal appeal, which has stopped the concerned court, as also before the coordinate bench of this honorable court.
For grant of anticipatory bail.
No, my lord. Here, what he says,
criminal
that is
appeal
before this
anticipatory
court, coordinate bench of this honorable court.
Correct. ಯಾವ matter le adu? Bail matter le.
That is page number 260.
That is bail matter.
Yes, not bail.
Then?
It's the criminal appeal. Yeah, bail matter. It's bail matter.
Yes.
Page number 260, my lord. Is there any? There is no single adjournment. The respondent number 2 has taken.
ಸುಳ್ಳು ಹೇಳಿ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ನಿಮ್ಮ allegation.
Yes. No. They alleged before this honorable court that we have taken umpteen adjournment, wherein we have not taken even a single adjournment.
All right.
The moment, my lord, 18/6, the case comes before this honorable court, that is coordinate bench, and 9/7, my lord, we files the wakalat. 9/7 we were present, and 10/7, my lord,
I will accept it that you have not taken any adjournment. I will correct this order. Don't worry.
No, my lord, here 9th. Next
I will
day
correct.
itself,
We will correct this order. Don't worry.
Yes. And next, my lord, next day itself they makes that statement. Another, my lord. Another, in the interregnum, what happens is, in a mortal hurry, the investigating officer in a complaint which had been kept in cold storage for 4 long years,
absconding charge sheet ಹಾಕಿರ್ಲಿಲ್ಲ.
has filed an absconding charge sheet against the petitioner, a C report. But wherein, my lord, if you go through the charge sheet filed by the
ಏನ್ ಹಾಕಿದ್ದಾರೆ?
It's a regular charge sheet, my lord, and within
Charge
it
sheet
has
is regular.
yes,
Regular charge sheet is filed.
it's a regular charge sheet being
The
filed.
report charge sheet.
and-
Absconding charge. Absconding charge.
What do you mean absconding charge sheet?
No, my lord, but
What do you mean absconding charge sheet?
But as per the SCST Act, my lord, it was
Sir,
not in a mortal hurry, my lord. There is no.
That's all right. Mortal hurry ಇದೆಯಾ ಇಲ್ವಾ ನೋಡೋಣ.
Times. my
Now
lord,
you
once-
told me it's a regular charge sheet. Is it a regular charge sheet?
My lord, 3
Is it a
times.
regular charge sheet? ಇಲ್ಲ ತಾನೆ.
But my lord,
Don't
after
go in-
serving
don't
3
get it-
notices.
You're a counsel. Don't get into the shoes of the client.
No, my lord, here
tell
actually,
me.
my lord,
Hmm.
it's a, after serving 3 notices, my lord, they serves, and that too, as per this SCST Act, 60 days has to be, charge sheet has to be filed. On 60th day only, charge sheet has been filed.
Charge sheet ಅಲ್ಲ sir, absconding charge
Absconding
sheet.
charge sheet has been filed, my lord. That is because they are not at all representing before the police. That is the reason absconding charge sheet has been filed.
All right.
So hence, while taking the interim order, as per the SCST Act, my lord, as
ಈಗ
section
ಇದನ್ನ
15.
1 minute sir. This is what was challenged before the Supreme Court.
Yes.
This order is not set aside. So this order has
My
been
lord, but-
confirmed. 1 minute. This order is confirmed.
High Court
Correct.
order is confirmed, my lord,
Correct.
but
So now don't go back to this order. Any correction ಮಾಡಬೇಕು ಅಂದ್ರೆ I'll do it. If you harp upon integrity of this order which is confirmed by Supreme Court, I'll not even touch it.
no, my lord, but
ಗೊತ್ತಾಯ್ತಲ್ಲ?
the Supreme
Yes.
Court says we have to hear vacating.
That is what I'm doing.
Yes.
Sir. Yes.
So, my lord, here, as per section 15,
Sir, you are not 1 minute, you are not arguing anticipatory bail application. You are on a 482 bail either. It's a 482 case.
Yes, my lord,
So argue 482 case. Don't get into, that's why I said, don't get into the shoes of your client.
no, my lord.
Argue on merits if you want 48 on the petition that is filed before the court. If you want time, take time.
No, my lord. Here,
But bail ಬಗ್ಗೆ ಇಲ್ಲಿ argue ಮಾಡಿದ್ರೆ I'll not listen to it. There is no time to listen to your bail application.
my lord,
here.
here, when the bail get rejected and the bail application another before this honorable court pending, they files this 482 and take this order. my
All
lord.
right,
That is
that
even
we'll consider
against
that.
SC Act section 15 completely violated, my lord.
ಅದು ಅಲ್ಲಿ bailಗೆ sir.
No,
ಏನ್ 482 ಹಾಕ್ಬಾರ್ದು ಅಂತಿದ್ಯಾ?
no, my lord, for all.
482 ಹಾಕ್ಬಾರ್ದು ಅಂತಿದ್ಯಾ?
No, no.
Inherent power of this court cannot be controlled by any other statute.
No, my lord, but here,
Yes.
my lord, the victim has to be heard as per the section 15.
ಇಲ್ಲಿ
Yes, my lord.
in 482 ಅಲ್ಲಿ.
Even in the 482.
Oh, seriously? Yes, sir.
No, my lord, here I will just
Sir,
go.
grant of ex parte orders is the inherent right. Don't tell me all this.
No, my lord, but
Bail ಅಲ್ಲಿ hear ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ 482 ಅಲ್ಲಿ hear
it has
ಮಾಡ್ಬೇಕು
been
ಅಂತ.
argued, my lord, before the Supreme Court, and hence the Supreme Court set aside.
Set aside?
No, it's not set aside, but ask the honorable.
We will hear you. I am hearing you.
My
I
lord,
am
here-
hearing you only on the merit of the matter itself.
Yes, my lord. Here, my
Yes.
lord, section 15A(5). I'm just go.
15A5, don't tell this court that this court has no inherent power to grant an ex parte interim order without hearing. No. Even in bail cases, I have said, yes, it is not mandatory.
My lord,
Yes.
here, when it comes to the
Why,
delay.
why it is not mandatory? Because of so many frivolous cases filed.
Yes.
Yes.
My lord, here, my lord, when it comes to the delay part, even in the last occasion,
ಅದು
also,
ಹೇಳಿ,
my lord,
you-
when I
See,
undertake.
don't focus on all those things that will not take you anywhere. If you want to argue the matter on merits, argue the matter on merits.
Yes. But it's not only the complainant.
Hmm.
There are eyewitnesses in this case.
Hmm.
That has to be examined, my lord. I will be independent witness.
Who,
He was present at that time.
he is an independent witness, is it?
Yes.
Not related to anybody?
Friend of the complainant.
This is the independent witness. How can he be independent?
My lord.
Anyway, we'll, we'll consider it, yes.
And another, my lord,
Who is he?
for this earlier statement, he is also friend,
Friend of the complainant.
complainant.
Both are friends of the complainant.
Yes, partner, my lord. And
Whose partner?
he is the partner of the firm.
Petitioners and
Petitioner's partner.
Both.
All right. He also says that abuses were hurled. Does
He
he
is
say
not an
that?
eyewitness, man. He is not an eyewitness.
Eyewitnesses ibre na?
For 208,
Eyewitnesses ibre.
yes.
Both
but,
friends.
But
Hmm.
that he gives a statement, that is
right.
observation, that
All right.
the accused has that kind of mentality.
Hmm.
My lord, here, my lord, it is admitted that before the DCRE, the complaint is presented after 4 months delay, that is
Correct.
3 months, some
Hmm.
days.
DCR ಗೆ ಹೋಗಿದ್ರಲ್ಲಿ delay, don't worry. But DCR ಇಲ್ಲಿ ಕಳ್ಸದ್ 4 ವರ್ಷ ಮಾಡಿದ.
Yes, that I will say, state, my lord.
Why does the DCR behave like this? If they are interested in the welfare of the SC, just immediate ಆಗಿ ಕಳಿಸ್ಬೇಕಾಗಿತ್ತು complaint na why? Now for the fault of the DCRE, why should any, not this complainant, why should any complainant suffer?
Petitioner, my lord,
Whole life
not-
ಹೋಗೋದಕ್ಕೆ ಏನ್
no, it's
ಸಂಬಂಧ?
not
Don't
only,
blow it.
he is not
It's
only a partner, my lord.
it's a partnership dispute.
No, my lord, he is not just, he became an advocate only recently, my lord. He was
I-
sole
sir,
and he
I have
worked his
heard him
entire
when he-
life in this.
One minute,
Whoever-
I have heard him when he was party in person also. Yes.
And my lord, here,
Hmm.
before the DCR statement, they states that there are number of police officers
Hmm.
who are investigating,
Hmm.
they kept on transferred. That was the reason, my lord.
ಅದು
it
ಮೂರ್
was
ನಾಲ್ಕು-
got
ಮೂರ್
delayed
ನಾಲ್ಕು
based on
anything
170,
else
my
you
lord.
have?
Please, 2 minutes.
ಆ,
Lord, with regard to the eyewitnesses, my lord.
ಅಲ್ಲ ಐವಿಟ್ನೆಸ್ ಇಬ್ರು ಫ್ರೆಂಡ್ಸ್ ಮಿಕ್ಕವ್ರು ಯಾರು ಐವಿಟ್ನೆಸ್ ಅಲ್ಲ.
They came after 3 years of the filing of the complaint, my lord. Eyewitnesses names have not been mentioned either in the complaint, my lord, before the DCRE, which is after 4 months delay. my lord.
DCR ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು ಅವಾಗ. ಇನ್ವೆಸ್ಟಿಗೇಟ್, ಇಟ್ಸ್ ಪಾರ್ಟ್
And
ಆಫ್
he has given his
ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
further statement, my lord. Allu eyewitness ಇಲ್ಲ. When, my lord, the DCRE would give a communication to him that there are no eyewitness in your complaint, so we cannot register the complaint.
Where is that, where is that communication? Which is that communication? ಇದು 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಹೇಳ್ತಾರೆ.
ನಾಲ್ಕು
2020
ವರ್ಷ
20 ಇವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ.
they would say,
ಅವಾಗ್ಲೇ ಮಾಡಿದಿದ್ರೆ he would have known whether it is registrable, not registrable and all these things.
no, my lord, they would clearly say that since there are no eyewitnesses to your case, we cannot register the criminal case. Then he has brought two eyewitnesses, my lord. Subsequent to this communication, he has brought two eyewitnesses.
ಅದನ್ನೇ
before the DC.
2020 ಹೇಳಿದ್ರೆ he would have asked God. No, DCR is fault. ಇಷ್ಟು ದಿನ ಇಟ್ಕೊಳಂಗೆ
This
ಇರಲಿಲ್ಲ.
case, my lord, he could have gone and completed the local police station.
ಅಲ್ಲ local police station ಹೋಗು. See, he has believed the DCR and given a complaint.
DCR is only an inquiry.
ಅರೆ, it investigates and communicates to the jurisdictional police. That should have been done ಅಲ್ವಾ?
No, it should also, you could have, in fact, my lord, your lordship may take page 27, my lord. Two paras, my lord, your lordship, see what he says. When there, he doesn't say that those eyewitnesses were present in incidents.
ಅದಿಲ್ಲ, that is true, correct. We'll see, yes.
In the
Sultan.
bail application, in the session court, while rejecting the bail, my lord, observe
Page.
some points.
Hmm.
Before DCRE, my lord, he submits that he was present in the said incident.
Well, it will see.
The incident has never, only with regard to the atrocities, we have to prove, my lord, and that is a part of.
What
trial,
are the
my lord.
other offenses? 504, 506 ಅಷ್ಟೇನಾ?
With regard to the spot, my lord, one small.
No.
And here I will.
Charge sheet ಅಲ್ಲಿ.
Charge sheet is part of my.
Charge sheet ಎಲ್ಲ ಹಾಕಿದಾರೆ, ಹಾಕಿಲ್ವಾ?
Next, it's
Charge sheet
in
is in
page
one
70.
Regular charge sheet ಹಾಕಿದ್ದೀರಾ?
Absconding charge.
Absconding charge sheet.
143 of my.
Then there is,
section.
there is no investigation done.
They have
Yes.
Huh?
Investigation is completed, but absent.
ಅಲ್ಲ, ಅವ್ರು ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ.
not- ಏನ್ ಮಾಡ್ಬೇಕಾಗಿ.
ಹಾ, absconding charge sheet ಯಾಕೆ ಹಾಕಿದ್ರು ಮತ್ತೆ?
Then he is not traceable, the victim. When there.
Who was not traceable?
Accused was not traceable.
Why do you want the accused?
Because that's, the
So why do you want the accused?
Third time, my
Hello.
lord, notice has been served.
ಒಂದ್ ನಿಮಿಷ ಸರ್, accused ಯಾಕೆ ಬೇಕು?
ಅಲ್ಲ, in the column, we have to say
Ah.
whether he is available for investigation or absconding.
No, when do you investigate the accused?
Will normally, if there custodial
arrest.
interrogation needed, we will ask them, we'll take them to custody and if necessary, arrest. them.
Arrest ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ.
He never got arrested.
I anticipate.
But there is nothing worth the name in the charge sheet, then you will have to cooperate with the investigation.
My lord, one submission with regard to, my lord, anticipatory bail, my lord, has been disposed of after 20 days, my lord, because of the complainant.
ಅದೆಲ್ಲ bail matters you leave, sir.
Bail,
No, there is,
What happened
now
to the-
there is no charge sheet in the case.
ಅಲ್ಲ,
charge sheet is filed.
now,
Charge sheet
no
is-
investigation is left.
No, everything is done.
Done, my lord, everything.
Then why did you file a C report?
47.
Wait.
Why did you file a C
No,
report?
it is absconding charge sheet, my lord, it is not
Absconding charge sheet is what is C report, when you don't
the report,
find.
my lord, is
It's 173C,
That
but it is 173, my lord. Regular charge sheet.
My lord, I was very much before the IO, before my rejection of anticipatory bail, my lord. Immediately, my lord, on the day I have given an
Go through
interim bail,
page
I have
number
appeared, my lord,
147.
may kindly,
Let's see.
I appeared before the IO, my lord. Kindly take this. Before the filing of the charge sheet, I personally, I went to the IO. I given this communication letter that interim bail has been granted to me. You can investigate. Prior to filing of the charge sheet, I have appeared. Kindly see this communication.
We'll see. Yes. Heard result. Interim order subsisting will continue to the disposal of the petition. Next.